go live. I'm attorneys general in Washington, D.C. And thanks for joining us today. We're here for a session on expert testimony, how to present forensic evidence in the courtroom. And this all evolved out of a partnership that the National Association of Attorneys General has with George Mason University and the National Institute of Justice that resulted in 3 years ago formation of the National Center on Forensics. We had a big forensic conference in Manassas, Virginia last summer, had about almost 200 people there. And we sent out a questionnaire afterwards that asked what type of follow-up training would the attendees need. These were medical examiners, coroners, law enforcement professionals, district attorneys, attorney generals. And so one of the items that came out was about expert testimony and how best to go about doing that, and how can you help and not help the prosecutor in these type of cases. So we have put together a program for you today that has two national experts in this area, Sam Miller and Mike Varone. Both of them have public safety backgrounds their whole careers. Sam was a detective and worked homicide and child abuse cases for years, among many other things. And he's now the senior counsel for the Massachusetts State Police Crime Lab. And we also have Mike Varone, who's a former prosecutor in Massachusetts, years of experience with expert witnesses and testimony. And so they're going to tag team today and talk a little bit about how you as professionals in forensics can help them in the introduction of evidence and help your prosecutors win these very important big cases. So I'm going to turn it over now to Sam and Mike. And just as a reminder, you can't ask questions live, but there is a chat room box. So if you have questions during the presentation, just please put your questions in there. And at the end of the session, Sam and Mike will take off and try to answer those questions if they can. So Sam, Mike, it's all yours. Thank you, everyone.
Thank you. Thanks, Mike. And thank you to the National Center on Forensics, George Mason University, and the National Association of Attorneys General for letting us take part in this training. This is something that we're both excited about and that we think is important, and we're happy to take part in this. Again, I'm Sam Miller. I work at the Massachusetts State Police Crime Lab. We are an ANAB accredited statewide laboratory system with 8 locations, and we provide forensic services to law enforcement all over the Commonwealth of Massachusetts. Mike Varone and I are both legal counsel for the Crime Lab. It's a job that encompasses a lot of different roles, and one of the roles that I think Mike and I both really enjoy is being involved in courtroom testimony training for analysts. Here at the lab, before an analyst is authorized to work in a given area, they have to complete a mock trial exercise where they testify, have a direct and cross-examination about a case file they've worked on during their training. And Mike and I get to play the roles of prosecution and defense for those mock trials. We enjoy it. I don't know if I can necessarily say that the analysts look forward to it every time, but they do come out of it feeling better, prepared to testify in court. And that's why it's worth it. So today, Mike and I are going to be drawing on our experience both in the courtroom and working with experts at the lab. And we're going to be talking about some of the things that our analysts have found helpful as they try to get better at presenting their work on the stand. It is a daunting part of the job. As Mike mentioned, I was in law enforcement. I've personally testified at well over 100 hearings and trials as a law enforcement witness. And I never once looked forward to it, but I did get better at it over time as I learned more about it. We've also both been prosecutors and have been on the other side of the witness stand doing the directs and the crosses. So hopefully you guys can come away with something from this today that helps you in your field. A quick kind of disclaimer: if we say something here in our presentation that conflicts with how things are done in your state or in your courts, please defer to the opinion of your local prosecutor or your agency counsel. There is a wide variety of local rules, opinions, and preferences with regards to a lot of the areas that we're going to be talking about today. And the folks who actually practice in your courts are in the best position to know what works there. So I'm going to start off with kind of a broad overview of expert testimony, and then Mike Varone is going to follow that up with a little bit of a deeper dive into the legal foundations, and then as was mentioned, we're going to have a little time for questions at the end. So first, the role of the expert witness, pretrial prep, and testimony. First, I want to talk about kind of understanding your role as an expert witness at trial. Oops. Okay. I like this quote a lot. We show this to our analysts during their training. If the law has made you a witness, remain a person of science. You have no victim to avenge, nor guilty or innocent person to convict or save. You must bear testimony within the limits of science. I think this is kind of a great position to be in as a witness. You don't have a stake in the jury's verdict. You don't have to win any arguments. A conviction or an acquittal isn't a win or a loss for you. You're there to add a piece to the puzzle that will assist in finding the truth, no matter what the truth is. In some ways, it's a luxury. The prosecutor has to try to prove guilt. The defense attorney has to try to establish reasonable doubt. In a lot of ways, it's kind of the opposite of what happens at the lab. You don't as a DNA analyst fire up the fusion powerplex thinking, come on, I got to get a match today. So it can be, I think, a disconcerting environment for an expert witness to be in sometimes. But the point of it is the point of how we try cases in the adversarial system is a lot like kind of the testing processes that scientific testing goes through. The point of the adversarial system is to have somebody on each side providing strong advocacy for both ends of an argument so that a judge or jury can make the right decision based on the best evidence. The point, of course, is to make sure that the evidence is thoroughly tested, all possible weaknesses have been explored, and that's what we want. That's what should happen in a criminal trial. I'd like to encourage our analysts to kind of embrace that process of testing. Even though testifying in court can be challenging, I'd encourage them to kind of embrace it because it's going to get to the right outcome. For me personally, the more I testified in court, the more I began to kind of think of it this way and appreciate the process. If I had done a good job on my investigation, I had nothing to fear from cross-examination. But more importantly, if I had missed something, if it turned out I didn't do my job as well as I thought I did, I wanted that to come out at trial. That's the last best time for it to come out before somebody gets convicted or acquitted on work that might not be sound. So try to embrace that process if you can. So on one hand, it's a kind of a luxury to be able to be impartial in a very result-driven environment. On the other hand, you have this unenviable task of explaining complex ideas, processes, and conclusions in a relatively short amount of time to a group of people who have no baseline understanding of the field to which you've devoted your academic and professional career. These people who you have to educate, you can't speak freely to them. They can't speak to you at all. You can only communicate with them by responding to a series of formally restricted questions posed by non-scientists who are duty-bound to attempt to bias the listener. So let the fun begin. To make this happen, it's going to take a lot of preparation. Sorry, I'm just trying to deal with Zoom here. Okay, so preparation is key. The best place to start once you get a subpoena or a summons to appear at trial is to reach out to the party who sent it. Usually that's the prosecutor, and that's for the purposes of this. I'm going to be kind of using the prosecutor as the default person who has called you in to testify. As you all probably know, if you work in forensics, you'd sometimes also get summoned or subpoenaed by the defense attorney or plaintiff or defendant in a civil case, because the work of forensics spans a lot of different areas. Some of the questions that you should be asking them up front. First of all, which parts of your work are going to be offered as evidence at trial? You might have tested 10 or 20 items in the case, but maybe only one is going to be introduced at trial because it goes towards the crime that's charged. Some aspect of your work that might seem significant to you may not end up being at issue at trial, or may not be a focus of what comes out at trial. So it's important to know kind of what you should be prioritizing and what you don't have to prioritize as far as your testimony goes. There also may end up being pretrial rulings or agreements that prohibit you from discussing certain things about the case, and the sooner you know that, the better. A big part of the job of kind of pretrial prep with the prosecutor is to educate them. There's a good chance they're coming into this case with a tenuous grasp of the science and processes themselves, and you're likely going to have to teach them a little bit before you get the chance to teach the jury. It's also good before trial to clarify any terms, any scientific terms or technical terms that could be stumbling blocks during testimony. One thing that comes to mind for me is something one of our analysts brought up recently. She was testifying about gunshot residue, and the prosecutor was using the terms stub and swab interchangeably. She made efforts to correct him on the stand, and it didn't get through, which made the whole direct a little awkward. So if possible, if you think about things like that before the trial, it's good to iron those things out so it goes as smoothly as it can. If there are any issues on the case that might come up on cross, or any developments that have happened since you did the testing, make sure the prosecutor is aware of those. And if you can, do a dry run. This isn't for you and the prosecutor to kind of like craft your answers or anything. It mostly gives them a chance to figure out how to word their questions in a way that makes sense, and that gets kind of the story of your work out. If you have lab counsel or counsel at your agency, utilize them if they're available. I know Mike and I, it's pretty common that there can be a miscommunication between a prosecutor and one of our analysts, where we know enough from kind of both sides of the coin that we can come in and kind of translate a little bit and explain the legal reasoning to the science people, and explain a little bit of the science to the legal people. Just a little bit though. I still haven't wrapped my brain around all the science here. Let's see. So the next step is that you're going to have to know your case. Review your case, know which items were submitted, how they were submitted, what you did when you got them, which tests you conducted, why you conducted those tests, how you conducted them, and what your conclusions were. Try to know as much as you can about your lab, accreditation protocols, the tech and admin review process, quality measures, evidence storage protocols, bench prep. Just think about everything you can to kind of establish the good work that's being done at your lab, and the protocols that ensure your testing is reliable. Know yourself, know your CV, know your job description, your current job description and your duties, and know the scope of your testimony for this case. You might be somebody who works in criminalistics and does crime scene response, and does blood spatter analysis. Depending on the case, you might only be able to talk about one of those things and not get into your expertise in other areas. Think in advance about how you'll explain scientific concepts in simple terms. Ask people you work with and practice out loud. I've heard a few of the analysts talking about how helpful it is to just, when they're driving in the car, to think about how am I going to explain why the uniqueness and persistence of fingerprint patterns. And they'll just out loud to themselves in the car, try to articulate that. It's one thing to understand it in your mind. It's another thing to get it out in words that a layperson, that a juror is going to understand. So practice, and all of you are going to be working with people who have testified a lot and who have had to figure out ways to communicate these concepts to juries. And I've met a lot of people here at the lab who have developed kind of go-to analogies or ways to explain things that really make sense and that help me understand it on a different level. So ask your colleagues and the more senior people at your agency. Know the court if at all possible. It always helps to get a look at the layout of the court before you have to go in there. If you can see how witnesses are led to the stand, all those things will just help you to make a kind of comfortable entrance and make you feel more comfortable on the stand. So I'm going to go into a little bit about direct and cross, and kind of generally what happens, and some of the things that can come up, and some of the things that we've seen come up during direct and cross. So the prosecutor's job, their role should be to facilitate your role as an educator. They're not allowed to ask leading questions. They can ask open-ended questions, and they should be questions that invite you to explain to the jury what it is you do and what you did in this case. To help accomplish that, a lot of the time the prosecutor will stand at a location that makes it natural to incline yourself toward the jury box. So they'll stand, kind of behind the jury so that you're naturally looking their way. The general structure of most direct examinations for expert witnesses is going to start with questions about your background, your education and training, your current job position, including your duties, the training that you had to undergo to get there, your proficiency testing, things like that. They'll ask about your laboratory accreditation, policies, procedures, and they'll ask about your experience in this area. If it's a certain type of drug test, they might ask how many times you've done that particular test in your career. They'll ask about prior times that you've testified as an expert, publications if you have any. Then they'll get to your work on the case at issue and the conclusions you drew as a result of your work. Going back to prior testimony briefly, it's a great idea to keep track of that. You might already have to. The federal rules now require that to be turned over to the other side with the notice of an expert witness. When the prosecution notifies the defense that an expert witness is going to be testifying, they have to send over certain materials. That now includes the history of prior testimony. In Massachusetts, our state doesn't require that, but because it's now required under the federal rules, and because our analysts occasionally get subpoenaed to testify in federal trials, we've instituted a policy where they have to keep track of every time they testify. Just more for them, so it's easy for them to produce that if and when they have to. Let's see. So some common issues that can pop up during direct examination. Open-ended questions that are too open-ended. Something like you take the stand and they say, what did you do in this case? And there's a lot that you did in this case. If you get a question like that, I think it can be helpful to give as brief an answer as you can that provides kind of a structure for the prosecutor to follow. So you could start off by saying, I was assigned to test 6 items related to lab number blank. And then hopefully that kind of invites them to say, let's talk about the first item. One of the things that can happen on direct is frequent objections from the defense attorney. Don't let it throw you off. And remember, with objections in general, there are a lot of reasons that objections happen, and it's up to the lawyers and the judge to sort that out amongst themselves. If you hear an objection, just pause, let it play out, let them settle things, and wait until somebody tells you it's okay to answer the question, or they ask you a different question. And if you've forgotten the question by the time they get back to you, you can ask them to repeat it. So cross-examination, I think that one of the big messages here is to leave the arguing to the attorneys. It can be difficult as a witness to sit patiently while an attorney asks kind of deliberately tricky questions, cuts off your answers, twists your words, but you gain nothing by getting into a back and forth or trying to win an exchange like that. As with all questions, and this is going to come up a few times in this presentation, when you hear a question, pause, take a breath, and then respond just as accurately and truthfully as you can. So the defense attorney's job on cross-examination is going to be to challenge everything that you just testified to on direct. To challenge your qualifications, your bias, your methods, your results. Where the prosecutor tries to position themselves to invite you to look at the jury, a defense attorney will often make themselves kind of the focus of the questions. So they may even stand between you and the jury, and they can ask leading questions, and they will and they should. There's no kind of general usual structure for a cross-examination. It might follow the structure of the direct, it might not, and it doesn't even have to happen. Cross-examination can be waived by the defense. So some common points of cross-examination that come up a lot. Challenges to your background and qualifications. Anything is pretty much fair game. They can challenge the sufficiency of your training, your education, your proficiency testing history, any nonconformances, corrective actions, disciplinary history. If you have mistakes in your personnel file or your QA file, don't be afraid to acknowledge that and explain them. Common challenges with forensic experts, a lot of defense attorneys will use the PCAST report, the NAS report, or bring in academic papers or publish and propose standards, anything that might conflict with your practices at your lab. If they bring in a report or a paper and they ask you if you're familiar with it, and you say you are familiar with it, I mean, as always, answer honestly. If you are familiar with it, they can question you on it. So if there are any kind of important papers or reports for the area you're testifying in that you know of, it's always good to review those before you go to court. If you have never heard of it, if they say, have you read the PCAST report? And you say, nope, I've never heard of it. Then they can't really follow up with questions about that because you've already said you don't know about it. So sometimes people learn that and they say, oh, good, I can just not read anything, and then they'll never be able to cross me on it. Ignorance is not bliss. The downside is that you're going to look like you don't know anything about your field. And there are other ways that they can get those reports in and still get to say what they want to about them. Another kind of common point of cross is things that you didn't do. That you didn't examine every single piece of evidence. You didn't conduct every conceivable test. And it's fine if they say you didn't test items 3 through 6 with this particular test. If you didn't do that, no, I didn't do it. You might get a chance to explain. There probably is a reason. Maybe your lab per policy only tests the items that are most likely to answer the forensic question presented by the case. Maybe certain tests weren't appropriate. And also, not for nothing, the lab can't test every single item that gets submitted. or there would be turnaround time would grind to a halt. In general, something to remember is that if you don't get a chance to explain something on cross, you can explain it. The prosecutor can give you a chance to explain it on redirect. So if it's important to the case, the prosecutor will on redirect come back and ask you to go into it. And then a couple of things, leading questions that lead somewhere and questions about, isn't it possible? So leading questions, are generally yes or no questions, and they can be used in a lot of different ways to get kind of the answer that the attorney's looking for. So I've got a scenario here, and I have kind of two approaches to how cross-examination questions could be asked about it. So the scenario is that during drug testing, you as the analyst, your supervisor authorized the use of a reagent that was 3 days expired. So one way that you could be crossed about this would be fair to say your lab policy says you should not use expired reagents, but you did so in this case. The analyst says yes. Why did you do that? The analyst explains the reagent was still good as it was only 3 days past the expiration date, and per policy, a supervisor can authorize a deviation in that circumstance. So that's not too bad. It came out. The analyst got to explain it, but defense attorneys usually are going to be a little craftier than that. So here's another way to approach it. You'd agree that the purpose of laboratory policy and protocol is to ensure reliable testing, correct? Yes. It's crucial then to always strictly adhere to lab policies so that you can produce reliable results, correct? Yes. In short, if you don't follow a protocol, you don't get good results, correct? It is your lab's policy not to use expired reagents, isn't it? Yes. But according to this table from your report, the reagent you used in this case was expired, correct? Correct. And there's no follow-up of why don't you explain why that happened? This may not be a perfect example, but you get the gist that these questions are designed to be very easy to agree to at first and then slowly box you in. Often something like this will be sandwiched in the middle of a longer series of somewhat innocuous yes or no questions that will elicit a yes response and kind of lull you into a pattern of agreeing. The best thing you can do one of the things you can do to kind of avoid getting into that pattern is, again, to pause before you answer, think about each question, and answer it as accurately as you can. So you can always say yes, but the attorney can say it's just a yes or no question. Maybe the judge will say restrict your answer to yes or no. But you can always say yes, but, or you can say I can't answer that with a yes or no. In this scenario, the analyst maybe could have said in response to it's crucial to always strictly adhere to lab policy, could have responded with something like, yes, but there are scenarios where it can be appropriate to deviate with prior approval, something like that. And at the end of the day, if none of those options present themselves, again, the prosecution can come back on redirect and cover that again and let you explain. So isn't it possible questions? I kind of get a kick out of these because it's like this is a question that can turn the most rational, reasonable scientist among us into a starry-eyed dreamer sometimes. A lot of people say, well, anything's possible. And that's just not actually true. Not anything is possible. So when you get these, isn't it possible or is it possible questions, try to remember to stick to what you know about this case, what you did on this case. That's the body of knowledge you have to answer the question of whether something's possible. And even things that are possible in the world in a broad sense may not have been possible in this case. And you may not have the information you need to determine whether or not that was possible here. So isn't it possible the evidence was contaminated before you got it? For example, at the scene or by somebody else in the lab before you did your testing? The truth is you don't know if it was or it wasn't. You could say, sure, it's possible that evidence can be contaminated in those scenarios. And in this case, if you have any indication that there was contamination, you can say that. If you didn't, you can say that. But you don't always have to concede that everything is possible. Think through it and figure out whether you can say that it is or isn't possible. A common one with secondary transfer type questions, they'll describe, some series of events that there was a strong gust of wind with the victim's DNA down the street into the defendant's apartment, and that's how it got there. Isn't that possible? Well, if I don't know enough about the literature, I guess, to say one way or the other, but if it's possible, you can say that's theoretically possible. I don't know if that's possible in this case, and I think you get the point. Isn't it possible you could have made a mistake? Everybody makes mistakes. Isn't it possible you could have made a mistake on this case? Answer it honestly. Review it. If you can't see a way that you're aware of that you made a mistake, you can say, there's no indication to me that I made a mistake here. Okay, so very general tips. Speak to the jury. Maintain a demeanor that reflects your impartiality. And that goes for whether you're talking to the prosecutor or the defense attorney. Take your time, listen to the questions, take a moment to think before you respond. Get comfortable with having a few seconds of silence. 3 seconds can feel like 10 minutes when you're up in front of a jury. But try to get comfortable with that. It allows time for objections, allows time for you to formulate your response, and try to get in a habit of doing that. Make sure you understand the question well enough to give a direct response. Don't be afraid to ask for clarification if you don't understand. If you can't answer yes or no, you can say, I can't answer yes or no. If you don't know, say you don't know. If you don't remember, say you don't remember. Your memory can be refreshed, your knowledge can't. And if you get asked a question and then 5 minutes later, you're on another question and you remember that you should have said something earlier, it can't hurt to say, I just realized that I needed to add something to my answer from earlier, or I misspoke earlier, and ask if you can have the chance to elaborate on that. There's not the worst that can happen is they say no, but it's worth a try. That's all I have. I'm going to hand it over to Mike Varone for part 2.
Good afternoon, and thank you for attending our webinar today. I would also like to thank the National Center on Forensics, George Mason University, and the National Association of Attorneys General for hosting us. My name is Michael Varone. I'm a forensic services attorney. I work with Sam here at the Massachusetts State Police Crime Lab. As he said earlier, one of our favorite things to do here, one of our favorite parts of our job is training analysts on providing testimony and running our mock courts. We also provide legal advice to laboratory management and act as a liaison between the laboratory and our partners and external stakeholders in the criminal justice system in Massachusetts. Before working with the lab, I spent approximately 10 years as a criminal prosecutor in Essex County, Massachusetts. I'm currently a member of the National Association of Forensic Laboratory Counsel, and today I'm going to talk to you about the different foundational standards applicable to providing expert opinion testimony. Then we'll go through some tips and other important information about preparing for and providing expert testimony in court. So like I said, we're going to start with foundation. And generally speaking, foundation for expert testimony was first established by a case called Fry versus the United States in the federal courts in 1923. Thereafter, it evolved with the implementation of the Federal Rules of Evidence, specifically Federal Rule of Evidence 702, and another case in 1993 called Daubert versus Merrill Dow Pharmaceuticals. And those are, for the federal standards, Of course, state-specific standards also apply depending on your jurisdiction. So we'll start with the Frye standard. The Frye standard is often referred to as the general acceptance standard. It's a 1923 case where the Court of Appeals of the District of Columbia examined the admissibility of lie detector test results in court. They stated, just when a scientific principle or discovery crosses the line between the experimental and demonstrable stages is difficult to define. Somewhere in this twilight zone, the evidential force of the principle must be recognized. And while courts will go a long way in admitting expert testimony deduced from a well-recognized scientific principle or discovery, the thing from which the deduction is made must be sufficiently established to have gained a general acceptance in the particular field in which it belongs. So after Frye, the test for admitting expert testimony was whether or not the theory or principle that underlied the expert opinion was generally accepted in that relevant scientific field. Frye standard was utilized in the majority of courts until 1993 and in all federal courts until 1993. In 1993, Daubert came along. The Daubert standard refers to scientific validity, and it was a Supreme Court case that examined the admissibility of an expert opinion that a medication caused birth defects. The Supreme Court held that the Frye test, which predated the federal rules of evidence, had actually been superseded by Rule 702, which at the time stated that if scientific, technical, or other specialized knowledge will assist the trier of fact to understand the evidence or to determine a fact in issue, a witness qualified as an expert by knowledge, skill, experience, training, or education may testify thereto in the form of an opinion or otherwise. So if Rule 702 superseded the Frye case, why is it called the Daubert standard? Well, because the court said that Rule 702 required interpretation, and they imparted on judges the responsibility to evaluate the reliability of scientific principles offered into evidence as expert opinions. They called this a gatekeeping function. And in order to give judges guidance on how to discharge their gatekeeping responsibilities, the Daubert court provided a certain list of factors that they should consider. The court stated that under the rules, the trial judge must ensure that any and all scientific testimony or evidence admitted is not only relevant, but reliable, and that the inquiry envisioned by Rule 702 is a flexible one. Its overarching subject is the scientific validity and thus the evidentiary relevance and reliability of the principles that underlie a proposed submission. The focus must be solely on the principles and methodology, not on the conclusions that they generate. General acceptance, or the Frye test, was no longer a precondition to admissibility, though it is still considered. The factors that the court laid out for the judges to consider are just that, factors for consideration. This is a balancing test, not a checklist. And those factors include whether the theory or technique can be or has been tested, whether it has been subjected to peer review and publication, whether it has a known or potential error rate, whether it has standards that control its operation, and finally, whether the theory or technique is generally accepted in the relevant scientific community. So Frye sort of still lives on as a prong of the Daubert analysis. Now, these factors, like I said, they're not a checklist. It's a balancing test. So whether one factor weighs more heavily in favor of admissibility than others is up to judicial discretion. Other factors can also be considered when appropriate. Daubert is now utilized in the federal courts. It's also been adopted in the majority of states, sometimes in a modified form. The minority of states still use the Frye standard, with some notable inclusions such as New York, California, Illinois, Minnesota, Washington, and Pennsylvania. Some states adopted neither Daubert nor Frye and instead used their own standards. If you're not sure which standard your state uses, then you should speak with your local prosecutor prior to providing testimony. Now, we talked a little bit about Rule 702 already. Well, what does it say now? Because it's changed a little bit since 1993. Right now, it says that a witness who is qualified as an expert by knowledge, skill, experience, training, or education may testify in the form of an opinion or otherwise if the proponent demonstrates to the court that it is more likely than not that A, the expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact in issue. This is sort of the relevance prong. It has to be relevant to an issue in the case. B, the testimony is based on sufficient facts or data. There has to be enough information for you to make an expert opinion on the case. C, the testimony is the product of reliable principles and methods. This is where Daubert and Fry come in. D, the expert's opinion reflects a reliable application of the principles and methods to the facts of the case. The expert must have applied the methodology correctly. What are the permissible bases for expert opinion? That's governed by Rule 703, which states that an expert may base an opinion on facts or data in the case that the expert has been made aware of or personally observed. If experts in the particular field would reasonably rely on those kinds of facts or data in forming an opinion on the subject, they need not be admissible for the opinion to be admitted. But if the facts or data would otherwise be inadmissible, then the proponent of the opinion may disclose them to the jury only if their probative value in helping the jury evaluate the opinion substantially outweighs their prejudicial effect. This is an important distinction between the permissible basis for expert opinion and the permissible scope of normal witness testimony. Usually witnesses are restricted in testifying to only those matters that are within their personal knowledge. Experts are allowed to testify regarding their opinion on matters that they're simply aware of. That opinion may be based on information, like I said, that is not necessarily even admissible into evidence as long as that underlying information is not brought to the court's attention. Expert opinion must be based on sufficient underlying facts or data, though. Expert opinion may also be based on hypothetical facts. A long tradition in American courts permits an expert to testify in the form of a hypothetical question, where the expert assumes the truth of factual predicates and then offers testimony based on those assumptions. So what is the scope of expert testimony? When you look at the scope, you have to remember the purpose. And the purpose of expert testimony is to educate the trier of fact on a subject that is within the witness's area of expertise. An expert should not offer opinions that are outside of the scope of their qualifications. And the scope is usually determined by the judge following a voir dire hearing. So what is a voir dire hearing? Well, voir dire just means to speak the truth. A voir dire hearing is a preliminary examination of a witness to determine qualifications and the scope of admissible testimony. Usually happens outside of the presence of the jury because the purpose of the hearing is to determine what the jury will ultimately hear from you. It may arise when a party files a motion in limine, which is simply a pretrial motion to determine what type of evidence will be admitted into court. And usually the party opposing the expert testimony will file a motion in limine to exclude or limit that expert testimony. This is where the judge applies the Daubert test or the Fry test or whatever state-specific test is in play. So what are some limitations on expert testimony? First and foremost, hearsay, with some notable exceptions. Hearsay usually is not permitted in court. Hearsay is an out-of-court statement that is offered for the truth of the matter asserted. Again, there are several exceptions to the hearsay rule, but usually a witness can testify about what they know from their personal experience, not from what they've heard from other people. Speculation is not permitted. Speculation differs from answering a hypothetical question, where the witness is asked to assume the truth of a certain set of facts in order to offer an opinion. Speculation, however, is when a witness guesses or doesn't know about the facts themselves. Quoting scientific authority or literature. Many states do not allow expert witnesses to quote scientific authority or literature on the stand because you're supposed to be the expert. And in doing so, you would substitute the author of the scientific authority or literature for your own expertise. There are some exceptions to that called the learned treatise doctrine, which we'll discuss momentarily. Testimony that exceeds the scope of expertise. you should always stick to your qualifications. Testimony on the ultimate issue, or what the jury is going to try to find. Rules vary on that. Generally speaking, the conclusions of a scientific report also cannot be admitted into evidence unless the analyst who has prepared the report testifies and is subject to cross-examination. This is because of the Confrontation Clause of the Sixth Amendment to the Constitution. There's a caveat there for substitute analyst testimony, which again we'll discuss momentarily. I mentioned the learned treatise doctrine. Generally speaking, learned treatises are accepted from the definition of hearsay. The rule, Federal Rule of Evidence 803, subsection 18, declares that a statement contained in a treatise, periodical, or pamphlet, if the statement is called to the attention of an expert witness on cross-examination or relied on by the expert on direct examination, and the publication is established as a reliable authority by the expert's admission or testimony, by another expert's testimony, or by judicial notice, learned treatises are accepted from the hearsay definition. This is why you may be on the stand with an attorney asking you whether a particular textbook or journal article is authoritative in your field. They're trying to establish it as a learned treatise. If admitted, the statement may be read into evidence, but not received as an exhibit. Testimony on the ultimate issue is governed by Federal Rule of Evidence 704. Generally, testimony on the ultimate issue in federal courts is okay. There is an exception, though, that in a criminal case, an expert witness cannot testify to an opinion about whether the defendant had a mental state or condition that constituted an element of the offense or of a defense. Those matters are for the trier of fact alone. And again, states differ on whether they allow testimony on the ultimate issue. So you should be aware of what those limitations are in your own jurisdiction before taking the stand. Mentioned the Confrontation Clause. Sixth Amendment to the United States Constitution guarantees criminal defendants the right to confront witnesses against them. In practice, confrontation occurs when a defendant has the opportunity to cross-examine a witness who bears testimony against him or her. I say bears testimony because it doesn't necessarily mean testifies. Testimony can be borne by other means than getting up in court and taking the stand. Testimony could take the form of a hearsay exception. A written document that's admitted into evidence pursuant to a hearsay exception is still subject to the Confrontation Clause. For example, certificates of analysis are testimonial statements that necessitate a defense opportunity to cross-examine their authors prior to admission. Rule 704 governs underlying data. I mentioned earlier that expert opinions can be based on information that is not admitted or admissible in court. The rule in the federal courts is that unless the court orders otherwise, an expert may state an opinion and give the reasons for it without first testifying to the underlying facts or data. But the expert may be required to disclose those facts or data on cross-examination. This is important because it is the basis for providing substitute analyst testimony. Substitute analyst testimony occurs when the analyst who performed an examination is not necessarily available to testify. A substitute analyst could review the raw data that is generated by the non-testifying analyst and then form their own independent opinion based on that review of raw data. The basis for substitute analyst testimony, again, is that underlying data principle. An expert witness may voice an opinion based on facts concerning the events at issue, even if the expert lacks firsthand knowledge of those facts. Modern rules of evidence continue to permit experts to express opinions based on facts about which they lack personal knowledge, but these rules dispense with the need for hypothetical questions now. An expert may base an opinion on facts that are made known to the expert at or before the hearing, but such reliance does not constitute admissible evidence of this underlying information. So an expert can form an opinion and testify to an opinion that is based on test results conducted by a non-testifying analyst, but may not testify about that underlying data generated by the non-testifying analyst on on direct examination. Some examples include a testifying analyst's independent opinion of objective raw DNA data generated by a non-testifying analyst that was admitted in the Fourth Circuit in 2011. In 2008, the Seventh Circuit allowed a testifying analyst's independent opinion regarding the identity of a controlled substance based on data generated by a non-testifying analyst. In 2007, the Fourth Circuit allowed a testifying analyst's independent blood toxicology opinion based on data generated by a non-testifying analyst. But the future of substitute analyst testimony is uncertain. Currently pending before the Supreme Court of the United States is a case called Smith versus Arizona, where the issue is whether or not substitute analyst testimony violates the Confrontation Clause of the Sixth Amendment. Oral arguments occurred on January 10th of 2024, and a decision is expected by the end of the current term, which ends in June. This will be a landmark case in our field, something we're watching closely, and it has the potential to change the entire landscape of substitute analyst testimony across the country. So now that we've gone over foundations, I'm going to talk to you a little bit about discovery. Discovery is the process by which prosecutors and defense attorneys exchange information prior to trial. In the federal courts, it's governed by Rule 16 of the Federal Rules of Criminal Procedure. In state courts, there are state-specific rules of criminal procedure that govern discovery. But in all jurisdictions, prosecutors are required to provide defendants access to certain information intended to be used at trial and any exculpatory evidence. This includes expert disclosures. The proponent of expert testimony must provide certain information prior to trial to the opposing party. In the federal courts, this is governed by Rule 16A1G of the Rules of Criminal Procedure and requires prosecutors and defense attorneys, if they're using expert testimony, to turn over all opinions expected to be elicited, the basis and reasons for those opinions, witness qualifications, including a list of all publications authored in the previous 10 years, a list of all of the cases in which during the previous 4 years, the witness has testified as an expert at trial or by deposition, and the expert's usually required to sign this disclosure. I mentioned exculpatory evidence. Well, what is exculpatory evidence? In its most basic form, it's information that's helpful to the defense. It's often referred to as Brady material because of the landmark case Brady versus Maryland, United States Supreme Court case from 1963, where the court held that suppression by the prosecution of evidence favorable to an accused violates due process where the evidence is material either to guilt or to punishment, irrespective of whether it was good faith or bad faith by the prosecution. Favorable evidence is that which relates to guilt or punishment and which tends to help the defense by either bolstering the defense's case or impeaching prosecution witnesses. The government must always produce any potentially exculpatory material or otherwise favorable evidence without regard to how the withholding of such evidence might be viewed with the benefit of hindsight as affecting the outcome of the trial. It is evidence that reasonably supports an inference the defendants seek to have drawn on any issue relevant to their guilt or punishment. Evidence is never exculpatory per se or in the abstract. Rather, evidence is exculpatory only by reference to issues placed in dispute by substantive criminal law definitions of the offenses charged and any affirmative defenses asserted. The meaning of exculpatory for any particular claim of a Brady violation must be determined in relation to an identifiable issue in the case. And where doubt exists as to the usefulness of evidence, the government should resolve such doubts in favor of full disclosure. You should remember that evidence can be exculpatory in one light and inculpatory in another, but the duty is to disclose any potentially exculpatory evidence, no matter what. The disclosure doesn't necessarily mean that it will be admitted at trial, but it's not for the prosecutor or for us to weigh whether the defendant should have it based on whether it's more inculpatory or more exculpatory. A piece of evidence could be fairly viewed as more inculpatory than exculpatory, but if it's potentially exculpatory at all, it should be turned over. Some examples include evidence that impeaches the credibility of a witness or casts doubt on an underlying investigation, inconsistent statements, witness cooperation agreements, documentation of the loss or destruction of evidence, contamination of a forensic sample, proficiency tests that did not meet laboratory expectations, findings of civil liability related to prosecution team members in the performance of their official duties, and evidence that would support leniency in sentencing, even if it's not probative of guilt or innocence. So how do you prepare for testimony? Like Sam said earlier, you always want to reach out to the attorney who's calling you to testify. Make sure that you understand the type of hearing and the attorney's expectations. Make sure that the attorney understands the scope of your expected testimony. You always want to be on the same page as the attorney who's calling you. Consult with your colleagues and supervisors and utilize lab counsel if available. Review your CV, study the case file and bench notes, and review all applicable laboratory protocols. You should prepare a copy of your CV and the case file to bring to court. Also, think about how to explain scientific concepts in simple terms. You need to remember your audience. You're not preparing to educate the judge or the defense attorney or the prosecutor who may have some experience in forensic science. You're preparing to educate a jury that's composed entirely of people who have no baseline in forensic science. So what are the different types of hearings you may commonly be called to testify to? You may be called to testify at grand jury, at a voir dire hearing, or at a trial. The purposes and rules of each of those hearings can vary wildly. So for example, the purpose of a grand jury is to investigate and charge a defendant with a crime. The purpose of a voir dire hearing is to determine a preliminary question of admissibility. The purpose of a trial is to determine guilt. While the rules of evidence apply strictly at trial, they do not necessarily apply at grand jury or voir dire. Leading questions are usually only permissible on cross-examination at trial, but they're permissible on direct examination at grand jury. On a voir dire hearing, it really depends on the issue that's involved and the judge. Authentication is required at trial, but it's not necessary at grand jury, though it is sometimes helpful. Again, it depends on the issue and it depends on the judge for a voir dire hearing. At trial, hearsay is inadmissible, but with many exceptions. Hearsay is allowed at grand jury, though. Depends again on voir dire, on the judge and the issue that's being examined. There's no right to confrontation at grand jury. Grand jury is a secret proceeding, but at voir dire and at trial, you're going to be cross-examined. The burden of proof also varies wildly. At grand jury, it's probable cause because the issue is whether or not the person is going to be charged. At voir dire, it's more likely than not, at least in federal courts. And at trial, the burden of proof is always beyond a reasonable doubt, which is the highest degree of proof in the criminal justice system. Regardless of the type of hearing that you're preparing for, you should always prepare in advance. So now you've prepared, and what happens when you go to arrive to court? Well, before you leave, you want to reduce the stress of testifying as much as you possibly can. You want to plan things out. Figure out where to park before you leave. Some courts have a nightmare for parking situation. Be prepared for a voir dire hearing. Make sure you're going to the right courtroom. Meet up with the attorney and go over any last-minute issues or questions before the hearing. Make sure you comply with any applicable sequestration orders. Judges often order witnesses not to discuss the case with other witnesses or with anyone else to make sure that they're testifying purely from their own memory. Recognize that the attorney calling you to testify may have little control over the trial's timeline. There may be other matters in the session. There may be other witnesses before you. It's difficult to tell when a particular witness is going to be able to testify. Recognize that sometimes continuances happen for a variety of reasons, and it may not necessarily be anyone's fault. Some practical considerations. Listen carefully to the question that you're asked. Ask for clarification if you need it. Ask the attorney to repeat the question if you didn't hear it. Make sure you pause and think before answering. Keep your voice up. Speak clearly and maintain eye contact with the trier of fact. This part can be awkward sometimes because the trier of fact is not the attorney that's going to be asking you the questions. Answer only the question that you are asked. If you don't remember the answer, ask for permission to refer to your notes or report, but be careful not to get lost in the papers. If you hear an objection, you should stop talking immediately and wait until the judge has ruled on the objection. Most importantly, you should tell the truth. Tell the truth even if the answer is I don't know or I don't remember. Don't try to deduce what the right answer should be or probably is. The right answer is always whatever the truth is. And if the truth is that you don't know or remember, then that is the right answer. If you don't remember, don't be afraid to ask to refresh your memory with notes or reports. Remember that attorneys on direct examination must ask open-ended questions. These are questions that are designed to allow you to explain yourself. These are usually who, what, where, when, why, and how questions. Leading questions are generally not permitted. This is your opportunity to explain your opinion. Remember that your job is to educate the trier of fact, and that the prosecution's goal at trial is to persuasively admit enough relevant information to allow the trier of fact to find the defendant guilty beyond a reasonable doubt. Be prepared to answer the reasonable degree of scientific certainty question. Recognize that authentication is required prior to admission of evidence. Authentication is governed by Federal Rule of Evidence 901, which states that to satisfy the requirement of authentication or identifying an item of evidence, the proponent must produce evidence sufficient to support a finding that the item is what the proponent claims it is. Anticipate questions like, how do you recognize this? Or is this a fair and accurate depiction? Chain of custody can be very important in authenticating an item of evidence. I mentioned refreshing your memory earlier. If your memory is exhausted, you can refer to your notes, but you should ask for permission first. Courts should be free in allowing expert witnesses to refresh their recollection from notes, records, sketches, and the like. And remember that the material you use to refresh your memory doesn't necessarily have to be admitted or even admissible in evidence. But what if your memory can't be refreshed? There's a rule for that too. Federal Rule of Evidence 803, subsection 5, excludes recorded recollections from the general prohibition of hearsay. Recorded recollection is a record that is on a matter the witness once knew about, but now cannot recall well enough to testify fully and accurately about. It was made or adopted by the witness when the matter was fresh in the witness's memory and accurately reflects the witness's knowledge. If admitted, the record may be read into evidence, but may be received as an exhibit only if offered by an adverse party. I mentioned the reasonable degree of scientific certainty question. That phrase is often utilized by legal professionals, but neither Daubert nor Fry requires it. It's currently under scrutiny by legal and forensic communities. The National Commission on Forensic Science has stated that the term has no scientific meaning and may mislead fact finders. OSAC has recommended that it not be used. And the phrase has been excluded from testimony in some courts, including the Southern District of New York, the District of Maryland, and the Middle District of Tennessee. But it's been allowed in the Ninth Circuit as recently as 2017, so the issue is far from settled. So what do you do if you are asked whether you formed an opinion to a reasonable degree of scientific certainty? Well, first, you should preempt the issue by discussing that question with the proponent of your testimony before trial. But if you're asked, it's okay to explain that your field doesn't use that term. As an alternative, you should explain that expert opinions, like all matters in the lives of human beings, are subject to some degree of uncertainty. Explain the method used to measure uncertainty in your discipline and how it applies specifically to your opinion in that case. On cross-examination, like Sam said, the lawyers are going to ask you yes or no questions. Lawyers are taught that a witness testifies on direct examination, but the attorney testifies on cross. They'll ask you questions that seem more like statements that they're only asking you to confirm or deny the accuracy of. They may try to trap you with statements that sound easy to agree with, but are subtly inconsistent with your opinion, methodology, or prior testimony. The defense attorney's goal at trial is to inject reasonable doubt into the minds of the jurors. He may try to accomplish this by discrediting you as a prosecution witness. Don't be afraid to try to escape the yes or no cycle by testifying that a question cannot be accurately and completely answered with a yes or a no. Always maintain a professional demeanor and do not take cross-examination personally. Remember that you are the expert, not the attorney. It's okay to be assertive as long as you're professional. Your job is still to educate the trier of fact. You may hear objections raised during your testimony. Objection is simply an assertion of error by a party to the case. They happen when a party thinks that a question is improper or that an answer might violate the rules of evidence or other procedural safeguards. Objections are usually made after a question is asked, but before the witness is answered, and witnesses are expected to wait until the judge rules on the objection. If the ruling is that the objection is sustained, the witness should not answer and should wait for another question. If the objection is overruled, the witness may answer the question as asked and may ask the attorney to repeat the question if necessary. Some examples of grounds are for leading questions on direct, speculation, hearsay, and a question that calls for an answer that's outside the area of expertise of the expert, relevance, question that's already been asked and answered, insufficient foundation, or compound questions. If an objection is sustained, but the witness has already answered the question, the objecting party may move to strike the answer. When an answer is struck, the jury is instructed not to consider it during the deliberations and to completely disregard the struck answer. But it can be difficult to unring the bell, so it's important to wait for judicial rulings on objections before answering to avoid the situation. I want to conclude by talking about the concept of reasonable doubt. To convict a defendant in this country, the jury must hear sufficient evidence to convince them beyond a reasonable doubt that the charge is true. By impressing upon the fact finder the need to reach a subjective state of near certitude of the guilt of the accused, the standard symbolizes the significance that our society attaches to the criminal sanction and thus to liberty itself. But what is proof beyond a reasonable doubt? Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after comparing and considering all of the evidence, the jury has an abiding conviction to a moral certainty that the charge is true. It is not enough for the prosecutor to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. Beyond a reasonable doubt is the highest degree of certainty possible in matters relating to human affairs. Prosecutors call experts to try to meet that burden. Defense attorneys call experts to try to disprove it. Thank you very much for your time and attention here today. Sam and I are both here for questions if you want to pose them to a chat. I've also put our email addresses up on screen.
Sam, Mike, can't thank you enough for the presentation. That was fantastic, amazing amount of preparation and so helpful. I did these type of cases for years as a prosecutor, and you are spot on in every way. So thank you so much. I don't see any questions in the chat room. So if we have none, I just want to touch base with everyone on the program today to talk about our next webinar. It'll be this coming Monday at 12 o'clock Eastern time. The title of it is called Navigating the Headwinds of Forensic Science Admissibility. Is it time to trim our sails? And we'll have Ken Melson, former senior advisor at the Office of Legal Counsel with the Department of Justice, is going to talk about recent developments and changes in the rules of evidence, how to use experts properly and appropriately. A really amazing topic that I've learned a lot about this last year: forensic genetic genealogy, admissibility in courts and legislatures and other cases. So if you're interested, please go to the NCF website and log in for that training as well and register, and we'll see it on Monday. That being said, I'm going to, I don't see any questions in the chat room, so we're going to close for the day. Thanks to all of you for participating, and we'll see you next week, hopefully. Thanks, Mike and